Why are you kissing a 6-year-old with your tongue? That's what I'd like to know.
Why am I kissing a
6-year-old with your tongue? I read all of the PSI reports.
I don't remember doing that, Your Honor.
Why are you penetrating a 6-year-old with your penis?
Yes, Your Honor. And I'm going to proceed with argument, correct?
Yes.
I didn't want to assume anything. So based on the offense stated, if you look at the child's date of birth compared to the defendant's date of birth, the child was 6 years old at the time of the offense, and the defendant was 28 years old at the time of the offense. This case is even more aggravated in the fact that this child, when she went and had her SANE exam, the fact that she had a SANE exam is terrible in itself. But as a result of that, she tested positive for chlamydia in both her anus and in her vagina. What's contained in the STIPs, and I believe the court can consider, is that this child said that he penetrated her anus and her vagina. And so it's clear what other way other than some sexual act by somebody does a child get this. And so these cases are already egregious in the nature that we have a child victim whose innocence has been stolen from them. But what's even more aggravating is the age difference that this child was 6 years old at the time of the offense. And what's even more aggravating is the fact that this defendant, presumably, all the evidence suggests that he is the one who caused her to have an STI at the age of 6, maybe 7 at the time of her outcry. And so we are asking, and I believe justice demands that you deny his application for deferred adjudication, and that we ask that you sentence him to the full 15 years because of the aggravating nature of this offense.
All right, defense.
Your Honor, obviously these are aggravated facts, but these cases almost always involve aggravated facts. And I think, Judge, what is going to determine how this case goes is whether or not the court believes that my client is worthy of redemption. And I would say that he is. I am asking that you put him on deferred adjudication. Notwithstanding the horrible mistake that he made, he has no criminal history. He's never been convicted of a felony. He's never done time in prison. He's never done time in county jail. This is his first offense, and it is a horrendous offense. But the fact remains he has no criminal history whatsoever. Further, Your Honor, if there is deferred adjudication, as the court knows, the court would not be limited to the sentencing range that it's limited today in the event that Mr. Rodriguez were to violate his deferred adjudication. Mr. Rodriguez at that point would be facing the maximum, which I think gives him incentive to behave himself while on deferred adjudication. Also on deferred adjudication, the court can order the treatment that he needs in order to rehabilitate himself. And the court could also order conditions to protect the complainant from the defendant. I'm asking, Your Honor, that you put him on deferred adjudication. This is a horrendous thing. There's not really anything I could say about that. But the fact is, I think he's worthy of saving. He has no criminal history. And I do think that I do think that he could right the ship, so to speak, Your Honor.
No, about the probation, if you do give it to me, you know what I mean?
All right, I thought you wanted to say something about the actual allegations.
No. I was going to say about the probation. Now, if you do give it to me, I promise, Your Honor, that I'll prove to you, and also I'll prove to my brother that's back there and my mom also. And why
are you kissing a 6-year-old with your tongue? That's what I'd like to know.
Why am I kissing a
6-year-old with your tongue? I read all of the PSI reports.
I don't remember doing that, Your Honor.
Why are you penetrating a 6-year-old with your penis? I mean, you pled guilty to it.
Yes, ma'am.
So I'm trying to figure out what were your thought process when you were penetrating a 6-year-old with your penis in the vagina and anus?
It was, yeah, I know I messed up and, you know,
Well, no, my question is why? What were you thinking while you were doing it? That's what I'm trying to figure out.
I just called over there.
All right, any questions?
I think you said enough, Judge.
All right, this is what the court is going to do. The court is going to find you guilty, sentence you to 15 years in the prison, give you credit for any time served. There's Chapter 62 registration and no contact with the complainant. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes.
But we can't turn back the hands of time. So you need to internalize what you've done, and hopefully this won't happen again with you. You understand? All right. Is there any impact or no?
No, Judge.
All right. Thank you. 2019 CR 8528, State of Texas versus Arthur Scarborough. And are you Mr. Scarborough? Showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney? Did you understand it? Are you the same Arthur Scarborough who was placed on deferred adjudication in 2019 CR 8528 for the offense of aggravated sexual assault of a child on March 28, 2022 for a period of 10 years? Is that you?
Yes.
State?
Violated conviction number 13B on or about the 24th day of August 2022 in Bexar County, Texas. The defendant, Arthur Etoku Scarborough, did then and there fail to comply with the instructions of the Bexar County Community Supervision and Corrections Department Sex Offender Program, and that the defendant failed to comply with the instructions of Lone Star Offender Treatment Program, his court-ordered sex offender treatment program, and that the defendant was suspended from sex offender treatment for failing to admit responsibility for his offense in violation of condition number 13.
How do you think to that? True or not true?
True. And the state would waive and obey the remaining allegation.
Did you understand by pleading true to violation of condition 13B, court could find it true, grant the motion, find you guilty, and sentence you to life in prison and up to $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to 13B?
Yes, Your Honor.
Court will find 13B true. Is there an agreement?
There is not, Your Honor.
Mr. Scarborough, you understand why you're here?
Yes.
Okay. And the at the the polygraph, they said that you denied liability or culpability. Is that correct?
Yes.
So did you ever deny that this thing happened?
No.
Okay. And tell the court what your thinking was.
At the time, I didn't want to believe that it happened. But I accept 100% responsibility and not partial responsibility. I accept 100% responsibility.
And so it was about who instigated the start of this.
Right.
Because when you took your polygraph, you said that she was as much of an aggressor as you were. That's not true.
That's not true.
And that you were
I was the
instigated.
aggressor, and I accept responsibility for that.
And that was the reason that he was expelled from the program.
Right.
State, do you have any questions?
Maybe true.
So I just want to make sure that I'm clear and I'm understanding is that you reported initially to your sex offender provider that this was unwanted and not provoked or initiated by you. Do you remember telling her? You did say that.
Yes.
And are you telling this court now that that statement is not true?
That's not true.
Okay, that this was wanted and that it was provoked by you.
Right.
Okay.
I've had a lot of time to think it over, especially while I was incarcerated for 61 days, and then I'm on house arrest for the 35 days. And I realized that I am the one that's at fault.
Okay. Do you remember having a conversation with your sex offender provider, Ms. Vicki Elliott, and her giving you that opportunity to say the truth?
Yes. And at that time, I didn't want to believe that was the truth.
And isn't it true that when she confronted with you about this and letting you know that you'd be exited from the program and that you would potentially have an MTR, that you still at that point decided that you weren't willing to take responsibility?
I did take responsibility, and I told her at that time that I accept 100% responsibility. But I still stuck to the story that I wasn't 100% at fault as the aggressor. But I realized after thinking it over for so much time that I'm 100%.
Okay. But you also
I accept the responsibility, and I wish to continue the truth.
and you understand there's a distinction between it's not really taking responsibility to say that a child provoked this, right? That's not really taking responsibility. You understand that? So when you said initially you took responsibility, that's not really taking responsibility.
When I talked to the counselor after I felt the polygraph,
I'm sorry? I can't hear you.
when I talked to the counselor after I failed the polygraph test, I did take 100% responsibility.
Okay.
But for her, that wasn't a good enough answer.
Okay. So you're still you saying that it happened, but that the child provoked it and that it was
No.
unwanted is taking
No.
100% responsibility.
No, that's not.
Okay.
I accept 100% responsibility. The child did not get responsibility.
I'll pass on this.
Any other questions?
Pardon?
Any other questions?
I just want the court to tell the court about your health issues that we're dealing with.
My health issues, I have a terminal illness called cystic fibrosis that affects my lungs, mainly my digestive system and sinuses. I have chronic sinusitis.
Which is why you're wearing the mask.
Yes, I can't be around. I'm real leery of germs. I have ulcerative colitis, and I have obstructive sleep apnea, where I have to be on a CPAP machine. All of those things that I didn't get the proper medications and things like that when I was incarcerated. And I don't want to go through that again.
And other than that one violation, you're behind a little in the money because you didn't pay while you
While I
were.
was incarcerated. Yes.
But other than that, there are no new offenses.
No new offenses.
And that you are the transportation for your mother.
Yes.
And your mother goes to the doctor, hospital,
Yes.
at least once a week.
A couple times a month, to the pharmacy as well, to the, I think, for grocery shopping. She's going to be 88 years old in a couple months. I'm the primary caregiver, which I've not been able to do for the last 95 days since I was locked up and in a house.
And she lives on your street
She lives 100 yards from me, but I can't go and see her
because of the monitor.
because of the monitor, well, house arrest. And I'm the one who takes care of her.
State, what are you requesting?
Judge, I'm going to request that this court revoke his supervision at this point. You've prosecuted cases, you have defended cases. I think this is a clear case where he still is. He's saying, well, I took 100% responsibility afterwards, but that's just not the case. That's why we're here. That's why he pled true, is that he didn't take responsibility. And that there is the inability at this point for the state to do anything other to ensure that our community is safe from him potentially reoffending. And that would be to place him in a corrections department so that he can't have access to children. This is a case that, obviously the state recommended initially, but that was, the court's aware that we do that in certain circumstances due to victim cooperativeness and really times taking into consideration the further well-being of victims. I think he was given an opportunity. He continues to not take this seriously or make good efforts in progressing his treatment. And so we're going to ask the court to revoke his community supervision and sentence him.
All right. Is there anything else for me to decide?
Nothing further to say.
All right. The court is going to grant the motion, find you guilty, sentence you to 10 years in prison, give you credit for any time served, Chapter 62 registration, no contact with the complainants, showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. You do have a limited right to appeal, and that is as it relates to the allegation in the motion, not the fact that you were on probation. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Good luck to you.
And that, folks, is how Judge Boyd closes the book on a predator who refused to look in the mirror. Let's recap. He got probation, blamed a 6-year-old for his actions, failed treatment, and got handed a 10-year prison sentence. The moral of this story? You can't lie your way through rehabilitation. You can't hide behind illness when you're refusing to accept reality. Judge Boyd saw through the manipulation and delivered justice, not revenge, but accountability. What do you think about this outcome? Was 10 years enough, or should he have gotten life? Drop your verdict in the comments below. Don't forget to like, subscribe, and hit that bell so you never miss a breakdown. Stay sharp, stay aware, and I'll catch you in the next one.